Okay, I think we're just at the half hour, so why don't we get started? We've got a lot of great stuff to cover today. My name is Joseph Caniglio, and I'm the Director of Antitrust and Innovation Policy, as well as the Schumpeter Project on Competition Policy here at the Information Technology and Innovation Foundation. On behalf of ITIF, I want to welcome you all to this really very special panel, Competition Policy in a New Administration, Conservative Antitrust and the Future of the FTC. So I do think the title really does speak for itself. And while we do have an hour and a half, there really is a lot to discuss. And I'm honored to have with me really a very, very distinguished panel of experts who frankly need no introduction. So I'm going to take the liberty of being brief so we can jump right into the substance. First, Maureen Olhausen, partner at the law firm Wilson Sonsini Goodrich & Rosati, where she is co-chair of the firm's antitrust practice. Before joining Wilson Sonsini, Maureen was an FTC commissioner from 2012 to 2018. Including as acting chairman beginning in January of 2017. I should say she's the only FTC commissioner to have received the Robert Potofsky Lifetime Achievement Award in recognition of her contributions to the FTC, which notably included being only one of two commissioners for about a year, as well as her extensive prior service at the FTC for over a decade, which included being director of the FTC's Office of Policy Planning. Thank you very much for joining us, Maureen. Second, Alden Abbott, a senior research fellow at the Mercatus Center at George Mason University School of Law, where he was also an adjunct professor of law for many years. Alden has had a distinguished career in government from 2018 to 2021, serving as general counsel of the Federal Trade Commission, where he had previously worked in a number of senior roles in prior administrations. Alden also spent many years at the Department of Commerce, including as acting general counsel, and additionally as special counsel at the Antitrust Division during the Reagan and Bush 1 administrations. He's also held high-level roles at BlackBerry and the Heritage Foundation. Good to see you, Alden. Third, Bill Blumenthal, retired partner at Sidley Austin, where he led the firm's antitrust group for many years. And also, if I may say, mentored a number of young antitrust lawyers, including myself, although I think it's fair to say I'm not the most notable of Bill's former associates these days. Before joining Sidley, Bill led the antitrust group at another large international law firm, and prior to that was general counsel of the Federal Trade Commission from 2005 to 2009 during the second term of George W. Bush administration. Bill has spoken and published widely on antitrust and competition policy issues, especially in the areas of M&A in international antitrust. Bill, welcome. Finally, Tim Muris, Foundation Professor of Law at the Anson and Scalia Law School at George Mason University and Senior Counsel at Sidley Austin, where he was, again, in full disclosure, my former boss. Tim is without question one of antitrust's greatest luminaries over the past many decades and served as chairman of the FTC from 2000 to 2004 and has the distinction of being the only person to have directed both of the FTC's enforcement arms, the Bureau of Competition and Bureau of Consumer Protection. His distinguished career also includes a number of positions in government, long career in private practice, as well as over 100 books, monographs, articles, and other publications. Very glad to have you with us, Tim. So, Tim, I want to kick the conversation off with you and maybe start with a little soundbite we heard from Chairman Ferguson. And I'm going to quote, Republicans of yore, this is a strange thing to hear, but this is the working person's party now. So are we at a new antitrust revolution and perhaps a new bipartisan antitrust consensus on populist lines? How do you interpret the current moment?
So let me thank you, Joe. And thank ITF. It's also great to see my old friends, Maureen, Bill, and Alden. We've worked together on many a project over the years. And I also should add that my views are mine and not those of George Mason or the Sidley law firm for whom I work. I think in answering Joe's question, let me talk a little bit about the lay of the land. I've had 6 jobs in the federal government. The first goes back to the mid-'70s. The last, as Joe mentioned, ended early in this century. And I've seen a fundamental change in the way people approach their jobs. Let me just take Congress. Congress members, even important committee chairs, do something different than they used to do. In the 20th century, they passed legislation, and you knew a member of Congress by the bill, or an important member anyway, by the bills in his or her name. That's just not true today. Not only are there fewer significant bills passed, but those that are passed are often written at the very highest levels of Congress, not even by committee chairs. An extreme example of the modern world, both in his behavior and perhaps in honesty, was Matt Gaetz, who said, "My business is chasing clicks." I don't think you can understand. It's just hard to understand Lina Khan, whose poor management has left a mess at the FTC, without recognizing the similarity to Mr. Gaetz. If Lina Khan was not good at management, it was because management was not part of her personal job description. Maximizing favorable publicity was, and she excelled at it. Now, it's always been true that running one of these agencies, that there were incentives to optics mattered, and especially short-run optics. And that often meant that when you focused on short-run optics, that you left your successors messes to clean up. But I wonder whether we're in a new era where optics aren't just important, but that they dominate. Now, Chair Khan had this very good fortune of leaving when she did, with her reputation high among her constituents, without facing, the problems, those inevitable problems of dealing with her mismanagement, including pursuing cases with little chance of success. Not just cases, but the unfair methods rule, for example. Now she can do the time-honored tradition of blaming every bad thing that happens on the failure of those who followed, and particularly given that those who followed, she can say that's MAGA. It's going to be easy for her to do that, especially for the opinion of those she values. And we have a media world that's quite dispersed. And, just as people on the right are talking to their media world, she can talk to her media world, and the two don't often intertwine. Now, Andrew Ferguson is no Lina Khan. He's in no way untethered from the legal obligations that his job requires to win cases. I think he recognizes the limitations of the FTC Act. Fealty to the law distinguishes the new chair from the old, but it only gets you so far with the statutes that they enforce. Take unfair methods of competition. There's no statutory definition. The Biden FTC wrote this, we know it when we see it, and it bears a striking resemblance to the one part of the 1964 cigarette rule, which is the beginning of all unfairness modern unfairness at the FTC. But the one part that no longer exists and that was abandoned by both the FTC and the Congress when it wrote a statutory definition of UDAP, that's the one part of unfairness that looks like what the Biden administration adopted for UMC. It is true that the case law and the relationship of UMC to antitrust has some limitations, but they don't eliminate the discretion. And we quite frankly, and that's an extreme example, but we quite frankly do not know how the new chairman is going to deal with that discretion. I think he's going to be a more careful steward than his predecessor. He's obviously intelligent. He's going to recognize constraints of the law and the constraints that Chair Khan has left him. But he also knows that his job has considerable visibility. And managing the commission's image has always been part of the leader's job. And it certainly is for anyone who's leading in this administration, which is more conscious of the new media than it's as conscious as one could imagine. So this focus on optics, which has always been there, but which was overwhelming in the Chair Khan era. I don't know how it's going to sort out, but I think we have to understand that difference in the modern world from the world that all of us on the panel lived in when we were at the FTC.
Thank you, Tim. Maureen, I want to turn to you. I mean, just quickly summarizing what I think Tim was saying, it doesn't appear that there's necessarily a bipartisan consensus, but maybe this new political world of optics where you might see some similarities across administrations. But how do you understand the current moment and sort of what sort of competition policy we might expect from the new administration?
Yes, it's a very interesting moment. And I'll say, as Tim said, my views are my own and don't represent the views of Wilson Sonsini or any of its clients. But I do think Lina Khan very expertly captured, or perhaps was meant to capture, this moment of using antitrust as a broader tool to try to address a whole host of issues that the progressives wanted to get actions done through Congress and were unable to do. So antitrust, and particularly unfair methods of competition, became a very broad brush tool to address all these, perceived imbalances or labor issues, or kind of what have you. And not that antitrust didn't have some of these elements in it before, but it became kind of a catch-all, and to a lot of acclaim from the press. But one of the things that I think really bears examination is that all these claims of aggressive antitrust enforcement really doesn't necessarily match up to the kinds of things that makes lasting change in antitrust law, which is bringing cases and winning them in court and getting favorable precedent into what is essentially a common law system of antitrust law. I think it's very interesting that there, didn't get very much attention to the fact that the rhetoric didn't really line up with the results, either by number of cases brought or cases won. But kind of coming into, taking over under, that sort of system, I think Chair Ferguson is being very astute in picking his battles, right? To come in and say, oh, I'm not going to be aggressive, or I'm going to, throw everything out the window, I don't think would be a very effective strategy, even for the goals that he has articulated, some of which are bringing regular order back to antitrust, things like that. He's also operating in a situation where the resources that will be at his disposal are rather limited, and on several grounds. First of all, he still does not have a majority. Now, it seems like Mark Mador, had his confirmation hearing, probably will get confirmed soon, give him, Chair Ferguson, that crucial third vote. Because you cannot, and I know because I ran the agency as an acting chair for almost 18 months with a one Republican, one Democrat lineup. You cannot undo things that were done by the previous administration that required a vote without a new vote and a majority to carry it. So a lot of the policy statements and other things that may have been done, cases that were brought forward that Chair Ferguson doesn't support, can't be undone until he has a majority. So I think it's wise to pick your battles and not necessarily go in and say, I'm going to redo the guidelines, the HSR rules. He's kind of sticking with what's there already. One of the other things that I think is a little bit underappreciated is your resource constraints across two fronts. One, the cases that have already been voted out are sucking up resources. They're sucking up staff resources. They're sucking up money, like even just for what transcripts cost for IHs or depositions, for expert fees, things like that. So your hands can be a little bit tied coming in as the new chair. Because of the actions of the previous administration. Then, across a third dimension, with DOJ, with the focus on trimming back government, it's not going to be likely that the FTC is going to get much of a plus up on any sort of resources, and may actually have some, it's under pressure to do cutbacks. So I think the chair really needs to pick his battles. And I do think that, he is articulating his goals, sort of marshaling carefully what he has at hand. He talked about, this labor task force that he's putting together. It's pulling together a lot of threads that are already there in the FTC authority and clearly there across bureaus on competition and consumer protection. I think that's really astute, and just sort of pull it together in a way that's thematically organized, even if it doesn't require a lot of new resources to bring it forward, and moving away from the UMC rulemaking that was such a doomed exercise by the previous administration. He's also talked about focusing on fraud, focusing on issues like pocketbook kind of issues for consumers. So, while I think there was this expectation that he might come in and kind of throw everything from the con time out the window, I think he's kind of chosen astutely those things that are popular, those tools that are available to him. And then we'll see, the devil's always in the details. What does this really mean for case selection? What does this mean for, and kind of going back to making lasting change through targeted, astute litigation.
No, thank you, Maureen. I think that makes sense from hearing from Tim. Obviously, we're not going to get neo-Brandeisian 2.0, but the same token, there's probably no going back, right? We have to, even from just an institutional perspective. But Alden, I want to sort of go to you next to sort of follow up with that. What might, if we can't go back to the old order and we're not going to get neo-Brandeisian 2.0, what might an overarching competition policy for the Trump administration look like? And just looking in other areas, sort of on the international sphere, for example, I know one of the things we've seen is the unfair exploitation memo and this sort of idea to push back against harmful foreign competition actions and other regulation against American companies. So could it be there's sort of a broader mercantilist idea that might animate the new administration?
Well, thanks for that, Joe. I don't know that I would use the term mercantilist necessarily for antitrust. Certainly the president said, for example, that he's concerned about the tax, which he views that has been imposed on major American companies overseas, in particular in the European Union, that regulatory actions and fines often he views as a kind of tax. He said he's concerned that, he's concerned about abuses by big platforms. He had said at least a few months ago, I think, that he would be very concerned about destroying the crown jewels, about breaking up companies. So those give you hints as to how enforcement might be carried out. I think both the Antitrust Division under Gail, Slater, and the FTC is certainly going to be continuing to carry out their platform cases. They've said as much, and indeed, I get there's a real question will come up in just later this month. In fact, there'll be continuation of a hearing in sort of the Google search case, and Justice Department near the end of the Biden administration recommended a breakup, sale of Google assets, including Chrome, as real possibilities. Will there be a retreat from that? One big question is, will there be the behavioral remedies? Will those be considered more seriously, certainly in vertical matters, as opposed to trying to litigate and avoid settlements? Although that was, at least the DOJ made a big thing out of that, but we'll have to see. I think Chairman Ferguson, I was looking at an interview I had with him a few months ago, podcast, so a bit of advertising, but he said, I view myself as an enforcer, not a policymaker, but I want vigorous enforcement. And he talked about, I think the history that, there's part of the history of antitrust is concerned about abuses, corporate abuses, big corporate abuses, not just government abuses, which he says are really there. He has suggested, I think, believes very much in the unitary executive. He's very skeptical about regulation. He certainly, and I think Commissioner Holyoke as well, and I would imagine that Commissioner Metter don't believe that there is any statutory authority to engage in substantive competition rulemaking. So 6G. So I think that will disappear. That will not have been a victory for the Khan administration. I don't think you're going to see any more competition rulemaking. As to consumer protection, there were almost 10 proposed consumer protection rulemakings. Almost none came to fruition. And of course, there have been a lot of critiques of sort of Magnuson-Moss consumer protection rulemaking. But I think that he expressed in the interview also his concern about going after fraud and deception and being a tough prosecutor. And again, the suggestion seems to me is that rulemaking is very costly and it's very time consuming in time of limited resources. You want to marshal your resources well. And again, as was mentioned, the labor, I think he says he is concerned about, the president's concerned about workers. Now, antitrust always recognized monopsony as a problem. So the idea that antitrust ignored labor prior to the last administration just wasn't true. There are some more complex questions though about defining labor markets, and there's some peculiarities there. But certainly, I think you'll see. He certainly said, Chairman Ferguson, there's a concern. Think about non-compete clause cases. That there may be some good competition cases involving non-compete clauses, even though was totally opposed to the rulemaking, which I think is certainly going nowhere. So you may see cases of that sort. I think you'll also get a policy unity between the Justice Department and the FTC, particularly because, as I say, Andrew Ferguson said he does not believe in, and he supports the president in attacking Humphrey's executor. I think there'll be an effort by Gail Slater and Chairman Ferguson to be singing from the same songbook, the same sheet. They're going to, I think, hopefully, I would hope, but in issues like IP, labor, on international matters, that they will be taking the same policy. Now, international, I think it's a real question there is, what position will the U.S., which engaged in plurilateral and bilateral meetings every year with major trading partners, which has been in the past very engaged in the International Competition Network, will there be an effort to say that we are not deferring to European view of competition, which is much more regulatory, much more viewed on a very risk-averse view, and the idea that sort of central authorities can much better guide competition. Will there be a pushback, say we are aggressive enforcers, but we do not accept the European view, the quasi-regulatory view, which has even increased with a Digital Markets Act and similar pieces of regulation or legislation elsewhere in the world. I think it's something to look out for. I suspect somehow there may be less focus on the big international pronouncements, although inevitably that's part of the job in the global economy, and a lot just on similarity of positions, which you may see in speeches by Slater and by Ferguson and the other commissioners. I think a detailed set to be filled in, but I don't anticipate. I'd be really, really surprised if there were any tension whatsoever. There's inevitable tension on things like clearances, bureaucratic tension behind the scenes, but in terms of policy, I don't see any policy tension between DOJ and FTC, because again, as I say, it's inconsistent with, I think, the view of the unitary executive, and we'll just have to see as cases roll out what happens.
No, thank you, Alden. I mean, I think we'll get to that question of whether or not there's going to be any daylight between the FTC and the DOJ. I think certainly the first Trump administration there was on certain issues. I'm thinking about IP, for example. But before we get into the enforcement side, I want to turn it over to Bill just to round out the policy question. So obviously, one of the most notable things about the neo-Brandeisians bill was their rejection or disfavor of the consumer welfare standard. And do we believe that with the new Trump administration, the consumer welfare standard is still going to be seen as normative? There has been some talk about other types of ideologies, maybe in other parts of the Trump administration's, sort of more social conservative ideologies. But what do you see? I mean, is the consumer welfare standard still operative in this new administration?
Well, Joe, thank you, and I should say it's good to be on the panel with this group, bunch of old friends, and good afternoon, everyone. I think the consumer welfare standard, by and large, is going to continue to be the main North Star by which antitrust is guided. It's been in the courts for a long time. It's been the way the agencies have tended to think. I think that it probably matters more in discussions like this, discussions within the antitrust priesthood, than it does to folks who, say, currently hang out in the White House. Staffs hanging out in the White House and the old executive office building, the Eisenhower building, and I think there may well be some circumstances where they say, well, if that's where the standard leads us, no, we're not going to agree with that. And I think we'll probably get into some of those details when we talk about enforcement specifics. But I would take them at their word. I would take Andrew at his word. But when I call him Andrew, Joe had mentioned in the early intros about how some of our colleagues in the group have gone beyond any of us on this panel. So one of the players who was with us in the practice, 9 years ago, was J.D. Vance, and Andrew Ferguson was one of them as well. And they've obviously both done very, very well in their career development. And they also have ideologies that are probably somewhat different from the old line priesthood that is represented on this panel. JD certainly more so than Andrew, but Andrew was always much more of an appellate lawyer than he was an antitrust theorist. And he very much got into the weeds on antitrust, but it was always from he was not one from Yale Law School, but it was sort of a Yale Law School type perspective on how you thought about things and how you thought about law and legal development, and how policy should evolve in the face of case law. And I would expect that he is going to tend to be quite loyal to the case law, but a line that says, "Well, I'm an enforcer, not a policymaker." I mean, how many times have we heard that from DOJ? How many AAGs have we heard say that in the past? I mean, it's kind of a regular mantra, but yet in making enforcement decisions, in framing the enforcement details, you can't help but deal with policy questions. And I think that, as I say, most of those policy questions are going to be addressed with the old case law as a starting point. The old case law tends to be largely sympathetic, or at least aligned with a consumer welfare standard, but not always, not completely. And to the extent there are policy deviations to be had, I would not be at all surprised if the notion that this is not the old Republican Party, this is now more of a working person's party, that notion comes through.
Bill, thank you. Please go ahead if you were going to continue.
No. Back to you.
No, thank you. No, I think that's fair to say. Just hearing from everybody, I don't think we're expecting any big policy shift. To keep the neo-Brandeisian mentality. To the extent there's continuity, there's some institutional reasons for that. But even in some instances, particularly international, we could see a very much sort of a shift to the right, so to speak, when it comes to protecting American companies abroad. But let's get into the enforcement specifics here. And Maureen, I want to start with you. You mentioned the merger guidelines. Obviously, that's one of the most important things that the agencies put out that sort of signify sort of where they're coming from. And obviously, we did hear in memoranda from the DOJ and FTC that for now, these are going to be operative at the agencies. So, I guess there were some questions as to maybe if once we did get a full Republican slate at the FTC, maybe they could have issued new guidelines. But what's your take on that decision? And even more generally, about the various policy statements that we got from the neo-Brandeisians. Tim mentioned the Section 5 statement. How much uncertainty is there out there for clients, both again with the merger guidelines and also more generally?
Yeah, so Chair Ferguson has talked about the merger guidelines as to the extent, and Bill mentioned this, I think, as a former law clerk, appellate law clerk, Supreme Court law clerk, he looks very much to the case law. And he also often talks about how, Congress, if Congress passed a law directing the executive to do something, it's kind of onto the executive to carry that out and also then to follow the interpretations that the courts have put forth. One of the interesting things about that, which I would like to see as under Chair Ferguson and under Gail Slater, how these guidelines are really implemented is the way they were written in 2023 harkens back to 50, 60-year-old case law, right? Supreme Court case law. And there's a reason for that. There's a reason that there isn't a whole lot of other more recent Supreme Court merger case law, and that is the HSR Act. Right, so the HSR Act was passed in the 70s. There was a change also to the antitrust expediting statute. So mergers were not consummated, and then the agencies try to catch up later, right? The whole thing shifted towards HSR notification for deals above a certain size, go into court, get an injunction. So all the development of the case law really moved to the district and courts of appeal. The way the 2023 merger guidelines were written was as if there was like sort of this system that existed outside our circuit courts and that you could come up with a case and then you didn't have to worry about actually, now maybe that's FTC Part 3, but otherwise you didn't have to sort of direct your complaint and your theories towards a particular circuit. Right. And so that's the thing that I think has kind of been missing is the idea that the circuit, the courts of appeal, they're all certainly very well wear a brown shoe. Right. And the question is, how have they interpreted it over time so that when the FTC or DOJ now tries to bring a case under the new merger guidelines that doesn't comport with that, what will happen? Right. So I think that will be really interesting. And I would presume that because he is focused on, being a more of an enforcer than a policymaker, I would imagine Chair Ferguson will be focused on those kinds of concerns. And you see his choice for bureau director, for BC director, is someone with a strong litigation background, like actually bringing and litigating cases. So I think that, will be really interesting to see how they sort of select their cases and theories with that in mind, without sort of, I think, the benefit of what Lena Khan got, which was, well, even if they lost, they won, right? Even if they brought a case and the court said, no good, but it really was a win. And we heard that on, across several cases. I don't think a Republican administration is going to get that kind of reaction if they bring a losing case. So I think that will be interesting. I think some of the other things that we might see are things that matter a lot to people who counsel clients and matter a lot to particular deals, which is re-engaging on settlements, re-engaging on allowing deals that have some, problem, but that can be resolved through a settlement to move forward, and then to have that settlement take place. And so I think that is another real change that I think we'll see, which I think will be important for counseling clients. There still is uncertainty, obviously, and one of the things we're hearing is that deals haven't sort of like come back to life in the way people expected at the beginning of this year because of that regulatory uncertainty. I think some of that will shake out, and we'll see, I think, maybe a little more confidence moving later into the year. I think one of the other things that we'll see is, they'll pick and choose what cases they continue to go forward with. One of the things Chair Ferguson mentioned in his dissents on the Robinson-Patman Act cases is Congress passed the Robinson-Patman Act, so he's not comfortable with just simply walking away from it, but he didn't think those were the right cases to bring. So what does that mean going forward once he has a majority? Is that how he'll want his limited resources to be used? So I think, we'll see some of the big tech kind of cases that were brought at the end of the previous Trump administration, or, some cases brought during the Biden administration will likely continue forward. And then I think we're going to see kind of for cases that don't fall in that sort of high profile, high, scrutiny bucket, I think a lot more return to regular order of not having, second requests and, just kind of out of curiosity's sake, and pursuing sort of very esoteric theories. As I mentioned, settlements will be part of the consideration. I think a move away from this idea of using the rules and the review to deter mergers across the board. That was a very strong effort in the previous administration because they didn't think mergers were valuable, right? So it didn't matter if they deterred mergers. They didn't believe that mergers overall brought benefits. So they weren't concerned about deterring pro-competitive or competitively neutral mergers. I think we'll move away from that in this administration. The high, the labor issues, the high tech issues will stay front and center, and pocketbook issues obviously will stay front and center. But I think we'll just see sort of a return for the deals that don't fall in that bucket to kind of do a more predictable path.
Thank you, Maureen. I mean, Alden, turning next to you. I mean, we've talked a lot about continuity, right? Potential continuity with the neo-Brandeisians, potential continuity with prior Republican administrations. What about new things that we might see from the Trump administration? And, here I think it's worth noting, in addition to the merge guidelines, the other big sort of policy agenda that the FTC has put forward is this censorship request for information consultation. So what do we make of the future of that effort, and specifically whether there really is a good antitrust theory to deal with censorship concerns? What's your take?
Well, censorship is tough because, as you know, there is something called the First Amendment. So that has to certainly be taken into account. I mean, I think they're going to be, in looking at what the platforms have done and their practices, the best argument would be if you found several major platforms, let's say, competing that are in advertising space and so on. If you had Google, Facebook, I don't know who else, and they had agreed to say, well, we are not going to look to advertisers who represent certain conservative speakers. We're not going to take their advertising, or we are not going to do certain things that favor or disfavor a particular group. In common, you could say, well, that is a form of collusion on quality, that you are agreeing, just as companies cannot collude and agree to only make a particular type of car or to compete in certain other ways. That would be the ideal. I doubt you're going to find things like that, though. I mean, there seems to be some evidence, as we know, that individual platform executives were having lots of conversations with the Biden White House about certain about curation and editorial issues, and of course, those things did not. The Supreme Court avoided looking at issues of standing, so it really avoided diving into that. But certainly, it is a fact that if the government in the past, suggests a particular viewpoint and quote unquote strong armed, or used economic pressure to get a platform to go along with that First Amendment protection, that is really a form of government coercion of speech. So the normal First Amendment protections probably would not stand. On the other hand, if I think there's very good case law, if individually a platform certainly had the ability to engage in editorial decisions, which could not be second guessed, and outside of promoting pornography or things not clearly covered in the First Amendment, broad discretion to do that. So I think it's going to be hard to find a good case. I think you can certainly try, but I would not be optimistic if I were the government about succeeding. And even cases, I'm thinking back to the Claiborne hardware case of civil rights days, in which there was collusion among supposedly orchestrated by the NAACP to engage in a joint boycott of Claiborne hardware. This was in Mississippi, which I think was engaging in racial discrimination. So it was sought. They said there was First Amendment protection, certainly for collective action of that sort, because in effect the speech rights of those companies were paramount. So even I'm not saying that would apply directly, but I mean there's other case law that says even certain types of group action by platforms may not, to the extent it talks about the type of views of speech, or we all think certain speech is obnoxious and harmful to the First Amendment. That's different than getting together maybe and saying, well, we don't think advertisers of a particular sort, well, we don't want to deal with them. So, but it gets tricky. So yeah, certainly there'll be attempts to find potential cases, but I would not hold my breath. As to what will enforcement look like, I think it's already been a suggestion that it's going to be continuing to go after continuing to platform cases. I doubt you're going to see new Robinson patent cases. I may be wrong. Chairman Ferguson had talked about power buyer, concerns about the power buyer exercising market power. And even there, I think he said that, look, yes, the statute is on the books, but there's also concern about limited resources and resource allocation. And as said, the FTC will have limited resources, and I think there'll be a lot of concern about using those resources in the highest valued use. And finally, I just might mention the big tech case as a footnote. Don't forget the case law. The Supreme Court case law on unilateral conduct has not been particularly helpful to plaintiffs. Not just Verizon v. Trinco, but there are a number of other Supreme Court decisions in its wake that make it hard, very frankly, to win a monopolization case. So I think that as the platform-based cases, if they proceed to the courts of appeal and they go to the Supreme Court, They may have a bit of tough sledding, but again, that's we'll see. That's off in the future. But one should remember, judges do use the justices have want simple rules, and an administrative system, as Justice Breyer said. It's law, antitrust law is sort of has to be administrable, and I think the approaches, like for instance on in pricing and other areas in single firm conduct, have made it hard for plaintiffs.
No, thank you, Alden. Bill, I want to turn it over to you now, get your thoughts on sort of what the enforcement landscape is going to look like, and maybe just flag a statement by Chairman Ferguson, who said, I think it's pretty close to a quote, that, he wants to continue the policies of the last 8 years, sort of suggesting that the first Trump administration and the Biden administration did have some continuity. So what are your thoughts on that, enforcement, and maybe what we could learn from the first Trump administration about sort of what the second one might do, kind of past his prologue approach?
Well, I guess I would say two things to begin. The first is I don't know that it's real easy to reconcile the first Trump administration's actions with the Biden administration's actions. I mean, those look to me like pretty different sets of theories on what antitrust is and ought to be. But I also don't know that I would rely too heavily on the first Trump administration as a set of signals for where the second administration is going to go. I mean, kind of harking back to where I began a few minutes ago. The folks who were running the agencies in the first Trump administration were from the kind of the old guard. That was especially true in Joe Simons, a little bit less so in Macon Delraham, but they were folks who would fit very, very comfortably on this panel. I don't think we're going to be seeing, well, we know we're not seeing agency leadership who are cut from quite that same cloth. And, I do think that there is some degree of reconciliation between at least where they are today and where the Biden administration was, in the sense that I think there are an awful lot of folks, and I got to put myself in this camp, who would say, well, I mean, Lena Khan wasn't all wrong, and Jonathan Kanter certainly wasn't all wrong. They were onto a fair number of things that people really ought to be thinking about. And to the extent, at least to the extent I part company, it's because I think on so many of those things, they went way overboard. Went far, they either didn't fully think it through, or having thought it through, ended up in places that I think most of us on this panel would say were pretty indefensible. But in terms of what to expect from at least out of the FTC, let me come back to the merger guidelines and the big tech censorship questions, because I think those are both pretty important. And I'll start with the guidelines. I was in the camp that advocated not throwing out the 2023 guidelines. I was in the camp that advocated, kind of keeping them in place, but saying, well, of course, we'll interpret them differently from the way that they would have been interpreted by the Biden administration leadership. But if you look at, at least the black letter at the top, the 11, big bold guidelines at the top of the various paragraphs, I don't think there's all that much objectionable there. I mean, they're kind of a checklist of a type that we would have gone through, at least mentally, quickly, sometimes with a glimmer of an eye, in pretty much any merger. Right? I mean, big concentration issues, yes or no? Okay, we need to look further. Big vertical issues, rarely, but we need to look further. To the extent I take issue with them, it's on a few details. I mean, some of the details are wrong, and in due course those ought to get cleaned up. The citation of old case law is pretty selective. I mean, selective to the point one would say pretty idiosyncratic. It's like General Dynamics never quite got written. I mean, they know it's there because they cited it at least once, but they kind of forget what it stood for. And the place where I think the 2023 guidelines are most damaging is in the area of verticals. There's just an antipathy towards vertical mergers, and a view that vertical mergers are almost never good. And I guess my own view is about 180 degrees off from that. I guess I would say that they can be problematic in extreme cases, but by and large, they're neutral, and I would go further and say, by and large, many of them are good. And they're not good not just because of double marginalization concerns. That's what people often talk about. But they're good because so many of them involve taking a small company, a startup company that has a good idea and some good technology or good product, but they don't know how to get to market. They don't know how to do the things that big companies do. And if they sell themselves to a big company, they suddenly have conduits into market. And those vertical mergers have been essential in getting so many products commercialized in a significant way and into the market. So to that extent, I think the 2023 guidelines are quite damaging. But I do think the current crowd is going to clean that up. Is going to clean that up very quickly. They may not say it all that loudly, but I'm going to be very surprised if we see the sort of focus on verticals that we had over the last 4 years. I should mention the new Hart-Scott regime. The agencies are collecting a lot more information than they used to. Now, partly that imposes significant costs on the business community. It imposes significant delays on the business community. We'll see whether the agencies withdraw those policies. I think that Chairman Ferguson is going to have a little bit of difficulty in doing that because he gave a pretty full-throated defense of the new rule. He said, it was a compromise. He wouldn't have written it quite this way, but he then spent an awful lot of time laying out the sort of the roadmap for the appellate defense of the HSR changes. So I'm not sure that I would bank on a significant change, but I sure hope they change them. I sure hope they go to something that is, well, in many ways is more European-like. I mean, more German-like, where, in Germany, it's, well, tell us what we need to know. If there's nothing here, send us a 2-page letter explaining that. And if there's something we do need to know, tell us what we need to know and why you think the deal is legal. But that's obviously a totally different framework. Big tech censorship. In antitrust theory, going after big tech censorship is, I don't want to say it's a non-starter, but man, is it tough. At least if it's going after unilateral conduct for the reasons that that Alden laid out. There may be more of a consumer protection theory that one can conjure up, to the extent that that platforms made express representations about how they would deal with the various content that gets posted, and if they are at odds with what one reasonably might read into those representations, maybe there's a little bit of a theory that one can come up with there, possibly. I think it's aggressive still, but there might be something there. But the main thing I'd be looking for is a collective action type of case. And I take Alden's point about Claiborne hardware. Query whether Claiborne really survived trial lawyers. That's a discussion we maybe can spend more time on in a different setting. But Because trial lawyers had some of the same notions, right? That this was a protest and we were acting collectively, but it was a protest. And I think John Paul Stevens dealt with that in I think it was a Stevens decision. Dealt with that very, very quickly. Just backhanded it. But where there is collective action, I think we might take some guidance from some of the activity over the last 4 years in the ESG area. Now that was driven mostly by state AGs, but there were a number of cases, especially on environmental types of coordination, where they started sniffing around. The state AG started sniffing around. The red state AGs, and clients would call and say, "Well, this is all political, right?" To which the answer was, "Well, it's clearly politically motivated, but that doesn't mean that it's without antitrust basis. In fact, there is significant antitrust basis to many of those complaints. Claiborne may be a defense, but query whether it really is." And you would tell people that, well, the fact that you ran overseas and did the coordination in Zurich or Geneva, and that you were doing it under color of the United Nations or the EC, is not going to give you a very strong defense in the United States. And even Lena Khan and John Cantor, they didn't say we're going to bring that case, but they were pretty careful in congressional testimony to say, well, that we don't recognize an antitrust defense to that type of coordination. And where we are seeing that type of coordination, either with respect to ESG considerations or some of the to the extent there's coordination between and among platforms on what content will get divulged and how, there may be a case there. I would not rule out a case in that type of setting.
Bill, thank you. Tim, your take on enforcement. There's so much to discuss.
For sure. Let me focus on two areas and say a few things that agree and some that are different, not necessarily disagreeing, but are different. And the two are big tech and the merger guidelines. And starting first with big tech, the new FTC team has inherited two such antitrust cases, both with complaints from the Khan Commission. One that was an amended Simons complaint that had been, dismissed. Now, if there's anything for which Chair Khan is known, it's her legacy of demanding of anti-big tech and demanding that it be dismantled. And these two cases put Chairman Ferguson in a no-win position. If he wins, and you got to understand what victory would mean to Lena Khan, and she's already been out there, talking about surrender. It includes a breakup. So if he wins, it's only going to be because he's done what she ordained. The victory will be Lena's, not his. And the prospects for that kind of victory are remote, to say the least, with Meta, and virtually impossible with Amazon. Whatever one thinks of that vertical case, which the vertical restraints involved, which incidentally bear literally no relation to her famous article, is subject to an extremely gerrymandered market. Even if they win, those sorts of restraints are just not the kind that American courts have ordered a breakup. So I wouldn't want to be certainly in this media conscious world in that kind of no-win position. Turning to mergers and all this discussion of the 23 guidelines, Bill, and what you're all, especially Bill, talking about, it really depends on what they mean in practice. Now, the previous guidelines, the 2010 guidelines, which are vastly superior, but that's not the issue on the table. But those were the most sophisticated use of rule of reason type analysis in antitrust, especially for that small use of mergers, that small number of mergers that pass the kind of screens that Bill's talking about. Things like the hypothetical monopolist test, the consideration of both coordinated and unilateral effects, analyzing the sophisticated customers, lots of questions. They involved the kind of economic analysis that was anathema to the Biden FTC. And when you look historically, there's of consumer welfare standard. There's a very interesting, very recent in Paris conference where Herb Hovenkamp, among others, and Ken Elzinga, it's about the consumer welfare standard. And Herb makes the point, well, the Supreme Court has always talked about price, output, and innovation. And that's true on its face. But what changed when the Supreme Court started using the term consumer welfare, and as Bill Kovacic has shown, I think persuasively, incidentally, in reviewing the court papers, Thurgood Marshall wasn't driven by Chicago. He was driven by, by our friends Phil Arita and the Harvard people. What changed is the use of economics. And that sophisticated economics, that is, you can read those 23 guidelines, and Susan Athey is a great economist. You can read those and say, sure, the economics is in there, but you can't see that in listening to the Khan FTC and to the way they approached antitrust. And I really doubt that sophisticated economics is going to be treated that way in the Trump administration. I really will be. One thing would really surprise me is antipathy to that economics. And as Maureen pointed out, and others, early termination is coming back. There's going to be something like regular order in investigation and the consent process. Now, there are a couple of issues to which I don't know the answer, but I can tell you what I think economics says, and those are two of the big changes in the guidelines. Bill mentioned the first, which is the non-horizontal mergers. I don't like what they had to say about non-horizontal mergers. The economics will tell you that there are good cases, but as Bill says, not very many. The other big change is this very dramatic and unjustified move in the numbers. The Biden administration didn't enforce those numbers, though. Now, maybe that was a second term. They're out there still waiting for the Biden second term. Maybe they were going to try to move the goal line. But that was a gigantic move if they'd done it, because remember what 2010 was. The stylized hypothetical merger, the 2500 was a 4-3 merger, and they wanted to move it back to where Bill Baxter had put it. Obama was much more conservative in that sense, and Baxter had put it at 6-5. I talked to Bill about this extensively. Bill was extremely gracious to me when I was director of Bureau Competition. Bill had been a structuralist in his youth, as a lot of people were before Harold Demsetz and others in the Early House Conference in 1973. But the FTC demonstrated, based on the population of second requests, that 2,500 and 4-3 was the way the government approached the FTC. There were 3 data releases, one while I was chairman, one while Bill was there, and one while John Leibowitz was chairman, looking at all the second requests, the population. And they showed that the FTC regarded, although they rarely challenged 6-5, sometimes 5-4, almost always 2-1. I mean, I guess Boeing, McDonnell, Douglas was, or 3-2, most of the time. 4-3 was really the 50. It was 50-50, I think, with unilateral, and a little more toward enforcement with coordinated. I may have that flip between the two, but it was reality. And Carl Shapiro has done us the service of looking at the current economics literature. And he says, on balance, there's just very little in the economics literature that justifies that movement. And I mean, there's some articles that are that people have pointed to, but when you get behind those articles, they don't justify a big move by themselves. And there's certainly many articles that are consistent with the current standards, and indeed, as those current standards reflected a lot of work by a lot of FTC lawyers over time. And the Justice Department didn't break things down in that detail, but to the extent they did, it was consistent. So Khan didn't enforce those numbers. Those are the numbers. I'd be surprised if Ferguson, if Chairman Ferguson, tries to enforce them, but we will see. Obviously, the government, those were the numbers in the 90s and through the aughts, and they weren't changed till 2010. So, as Bill said again, what the guidelines means, a lot of it depends on how they're actually enforced. So we don't know, but we do know that economics matters enormously. And the Khan Commission had a distinct anti-economics view, and I'll be surprised if it continues.
Yeah. Joe, can I just pick up on what Tim was saying and offer one further thought on the guidelines? There are two very, very different types of guidelines. If you look at the many, many guidelines that have come out of the agencies, and I wrote an article about this, 30 years ago, you have some that are fairly algorithmic. And you have others that are much more in the nature of, here are some things to think about. I mean, the high watermark for the algorithmic guidelines were the 1982 Baxter guidelines. We typically wouldn't have all the facts. But if you had all the facts and you cranked them in and kind of turned the handle, you would get a unique outcome. I mean, they would give you the answer. Now, the history of the guidelines since 1982 has been walking back a little bit more in the area of increased discretion, in part because the economics have gotten more complex than they were in 82. The 2023 guidelines are of a totally different type. They're not algorithmic at all. Here are a bunch of things to think about. And on the numbers, it's, hey, when we start getting to these numbers, we need to think about it harder. I mean, I don't think that they are saying we're going to, the courts need to challenge these. It's we need to think about it harder. And maybe Slater and Ferguson will, maybe they won't, but fundamentally, I mean, my take is they can live with the guidelines. The guidelines mean, the 2023 guidelines can essentially mean, anything to anybody. Depending on how you want to read them, how you want to interpret them. And my guess is that they're going to interpret them a lot like merger policy looked, in the first Trump administration. That's one area where I wouldn't expect a lot of change.
Bill, thank you. I think it's an interesting point, although I would note, at least on the concentration thresholds, there's some pretty strong language about presumption of illegality that does mean a little something.
Yeah, it's going to get overcome readily.
So we got about 20 minutes left here, and we've got some questions from the audience, and I want to invite folks to continue to throw some questions to the group, because I do think I want to open it up a little bit now into a discussion. And why don't I start with Alden and ask, you mentioned, I think before, Alden, the unitary executive theory. And, we've heard from Chairman Ferguson about his disapproval of Humphrey's executor and other statements about the FTC implementing the Trump agenda, and just a strong consonance with the FTC, and maybe just the fact that maybe agencies aren't as independent as they're made out to be. So taking those statements and that sort of posture with some of the things we've heard in Congress regarding the possible One Agency Act, I know that's something that you wrote about. How does that all fit together? And what are the chances that maybe consistent with a lot of the efforts going on with Doge and Elon Musk, that at some point we no longer have the FTC with a competition mission?
Well, full confession, I did write something I had never, I sort of changed my mind a few months ago. I wrote an article in Forbes endorsing, in essence, the One Agency Act, because the argument was saying, look, argument eloquently made by Tim Muris and others that the FTC had this special ability in an administrative court, and in fact, to tease out some complex, tough antitrust questions in Part 3 proceedings, and some good law came out of that. Yes, that's absolutely right. But my real concern was that there are too many inconsistencies. It's in terms of rule of law, different standard, different injunctive standard, even though the agencies argued it was basically the same between the two agencies. There was Section 5, the greater concerns, I think, by the Supreme Court about independent agencies and due process, and the idea that you had these administrative actions that you could get a second bite of the apple, at least in theory, in merger cases. That the Justice Department had to go directly into federal district court. All of these things created sort of, in my mind, rule of law issues. And people said, well, take it with a grain of salt. But under the Khan's administration, taking a lot more power into the chair's office, acting arguably more arbitrarily, supporting promulgation of Section 5 unfair methods of competition guidelines, which were totally untethered to anything other than the sheer will of a majority of the commission. Like them or not, and I know Maureen Olhausen critiqued them, the 2015 guidelines, a statement of unfair methods of competition, at least seem to say that, well, look, fewer Section 5 cases, there has to be some real harm to consumer welfare or cabin, some sort of rule of reason framework. That got totally thrown out the window. Now, admittedly, I think if anybody brought a crazy Section 5 case, it would not survive. But it's just in terms of efficiency, there's no reason when the U.S. has argued overseas that that one agency is best, made that argument. It was no longer good substantive justification, I thought, for the weird historical reasons you have two antitrust agencies, and even more complications since you have state AGs, but that's a separate question. Realistically, I don't think it's going to happen next few years because it might, but the One Agency Act has been reintroduced in the House and the Senate, but the Commerce Committee committees are certainly going to get involved. It's always been conventional wisdom. It would never happen because the Commerce Committee wants to protect the turf, and it's of the FTC and wants a hand in antitrust, and that's probably still the case. I still don't think, as a matter of principle, for a variety of reasons, it doesn't make any sense logical sense to maintain the two different enforcement regimes. Having said that, I think we're going to live with the two enforcement regimes for a while, if not indefinitely.
Alden, thank you. Tim and Maureen, you have both been named, so I will let you respond in that order, and then we'll let Bill get in.
The act is consumer protection, and I think the proponents of the One Agency Act are going to find themselves on the top of Elizabeth Warren's Christmas card list, because if they succeed, you're going to leave the FTC with only consumer protection, which would be a bad thing. I think the combination of the two has worked well for both parts of the agency, but especially for consumer protection. although the synergies, I believe, have run both ways. But if you have an FTC that's only doing consumer protection and a CFPB, which has much more powerful, authority, either when the budget crisis comes and forces some sort of bean counting exercise to rationalize the government, or when the Democrats have power, I think we'll end up enhancing the powers of the CFPB. It's true, just adding now, that the CFPB has been cut back, but that's because Senator Warren wrote an agency where she gave enormous power to the director to do things, and she, I suspect, did not realize power to act included power to not act, and the Trump has seized on that to do all sorts of things, or to not do all sorts of things, and they're screaming about that. But that's what happens when you give this enormous power.
Okay.
Sure. So two points. Alden mentioned my dissent on the 2015 Unfair Methods of Competition Policy Statement. And the reason for my dissent there was it was so abbreviated as to have no real content. And it also wasn't open, put out. We had no public input on it, which to my mind made it easy to sweep away. It was easily swept away. Maybe it would have been swept away anyway in the tsunami. But it's not that I think it's a bad idea. In fact, I think kind of going back to the history of the FTC, last time the FTC got in a lot of trouble with Congress was using unfairness on the consumer protection side and also doing sort of unbounded rulemaking on that. And what we saw was Congress actually defined unfairness for the consumer protection mission, and also gave the FTC much clearer authority with much more stringent guardrails for doing consumer protection rulemaking. So one of the things that could be considered to address some of these issues, because one of the problems of just sort of like swinging back and forth between broad policy statements and narrow policy statements, and broad assertions of rulemaking authority and narrow, and saying we don't have that rulemaking authority, is you get the pendulum swinging back and forth. And so the FTC had for many years, because of that understanding of what happened when the FTC on the KidBid rulemaking went down this road and the risks of the entire agency, acted, I think, with that concern in mind, which the con people threw out the window. They just didn't agree with that. So I don't feel confident that the next 20 years will again have this kind of restraint. So it's possible, for the type of reforms Congress could look into, would be to define unfair methods of competition on the antitrust side. I don't think the agency should get competition rulemaking because of the dual enforcement with DOJ. I think that creates a kind of enormous efficiency. Another thing that I think should be fixed is having the same standard to get a preliminary injunction. And also not using, Alden, you mentioned the second bite of the apple, right? Oh, we lost in federal court, but now we're going to still continue our administrative litigation, challenging an unconsummated merger. I think that's very problematic. So, thin reed to hope Congress would step in and clean up some of these things, but it did happen back in the day on the consumer protection side.
All right, thank you. Bill, your thoughts?
Well, for 50 years or so, the question, why do we have two agencies, has come up with some regularity. And the answer, invariably given by the agencies, especially the FTC, is, well, you would never do it this way today. But the costs and burdens of integrating back into one agency are probably more than they're worth. And the question on the table right now, I suppose, both under the One Agency Act, but more generally in light of DOJ and the other changes that the administration is planning to make to the structure of government, is that still the case? Is it really still the case that it's more hassle than it would be worth, or might it be worth it? And I'm agnostic on on what the answer is. But the one thing that is fairly clear to me is that the proposal of simply taking the Bureau of Competition and airlifting it into DOJ antitrust is not the right answer. It's not the right answer, partly for the reason that Tim gave. It's what do you do with the residual part, really with the residual parts of FTC, not only consumer protection but also policy studies, where policy studies is where a lot of antitrust policy gets studied in a way that DOJ does not. But the other piece of it is that the culture of the agencies, at least at the margin, has been somewhat different, especially in the Section 1 area. The DOJ has criminal authority, and the criminal authority sometimes spills over into the willingness for how they speak about collective action on the civil side. And the FTC obviously has both the consumer protection side and the policy study side, and both of those spill over to some degree in how the FTC speaks about competition. And the way that those resonate out of the two agencies is somewhat different. Now, whether it's good to have the two separate voices or not, again, is part of the broader debate. But one place where you saw it was the competitive collaboration guidelines, in 2000, where DOJ was just so frozen about not wanting to say anything that might undermine the criminal mission that they were incredibly guarded in what they would say in the way of guidelines for bona fide competitor collaborations. And, while there were a few things in there that were, to use the term I used before, sort of algorithmic and safe harbor, but most of those guidelines were mush. And, I'm not glad that the last administration repealed them, but I don't think there was a tremendous amount of damage done from that repeal because they were an effort to try to reconcile these two different visions out of the two agencies. If there is going to be an effort to restructure the antitrust mission, and as part of that restructure the consumer protection mission necessarily as well, I think some serious thought needs to be given to how that's going to get done. If it's done in a fairly slapdash way, an awful lot of China is going to get broken.
Thank you, Bill. I think we've got time for one more question. This sort of comes from the audience as well. And I want to make sure everybody has about 1 or 2 minutes to weigh in, and it goes to the courts. So I think it's fair to say that if you're going to have really an antitrust revolution, you not only need to have agency officials who are on board, you also need to have an ideology. But again, the courts need to go along with it. And I don't need to remind folks on this call that before Reagan took office, you already had the Supreme Court in Ryder v. Sototone say that the Antitrust Distribution Act was a consumer welfare standard. So to what extent do we think that the courts might actually get on board with this sort of populist agenda going forward? Why don't you start? Bill?
I think it's pretty unlikely, but I also think that the agencies are going to know that it's pretty unlikely. So it's not as if you're going to go running into court and advocate a revolutionary take on antitrust in aid of sort of a broad populist mission. I mean, you may well take some populist enforcement decisions or populist motivated enforcement decisions, but you're going to frame them in ways that the courts historically have spoken. And boy, I mean, if anybody knows and understands that, it's Andrew Ferguson.
Alden, your thoughts?
Yeah, I think, look, I think if Harris had won and with a Democratic majority, there were lots of sort of critical legal studies, sort of post-modernists who were put on lower courts during the Biden administration. With enough of those eventually on the Supreme Court, why not? I think, frankly, with the current Supreme Court as it is, and particularly people like Justice Gorsuch, who was an antitrust professor, very much a sort of a near cost Frank Easterbrook type of scholar. I don't think that any sort of neo-Brandeisian nostalgic ideas certainly would come through, not in Section 2, but also I think once, if you ever get a merger case at the Supreme Court, it's not going to look like anything that the neo-Brandeisians would have liked. But again, I think I agree with the point that look, they are trying their efforts to prosecute the big platform cases. I think they're losing cases for the Supreme Court, but under orthodox theories, vertical theories of harm, say, I don't think they're ones that will succeed, but I think any and for that matter, even the Biden administration prosecutions, they didn't come up with neo-Brandeisian notions in the complaints. They were trying to tie. There was some references to labor market, which were dubious, but they were trying to tie it to orthodox theory. So that's my view.
Alden, thanks. Maureen, I want to ask you the same question and maybe just also raise, one of the things I think the neo-Brandeisians have tried to do is appeal to conservative legal theories like textualism and things like that in order to try and get conservatives on board with what they view to be their approach, an idea that maybe textualism will be more conducive to a neo-Brandeisian approach to the antitrust laws. Might that be successful, or your thoughts on the courts generally?
So look, I think they have tried to do that. We see it, I think, in the defense of the UMC non-compete rule, right? But the way they did it was by excising 2 words or 3 words out without looking at the broader structure. And that didn't even fly. Like, one thing that I look at is, how did that fly with the Supreme Court, say in the AMG case, right? They lost that case 9-0, right? The court as a whole looked at, well, how does this fit into the whole statute, not just pulling a word out here or there. So I don't think that is going to be. I know they're trying it, but I don't think it was successful. And I don't think it's going to be successful. I think the other thing with the courts is, kind of getting, like, you can get district court opinions that go one direction, or the other. And I think you touched on it implicitly about the Qualcomm case, which was brought at the end of the Obama administration. I dissented. I was not able to stop the train, right? Even while I was acting chair, there was a district court opinion that upheld the FTC, and then a very, I would say, sort of emphatic Court of Appeals decision holding the other way, with 2 Obama appointees on the court, right? So I do think that, you have to kind of get beyond like the random district court decision here or there to really change the case law at the Court of Appeals level. And I think that is going to be difficult. Getting an unconsummated merger case before the Supreme Court seems very unlikely to me. So I think, we'll see maybe some conduct cases make it up there. But the way the court has been using textualism, but not like just a random word here or there, and certainly not delving deeply into legislative history kind of things, I think doesn't bode well for the neo-Brandeisian approach, making a lasting impression in the courts.
Maureen, thank you. Tim, you get the last word. Is this another revolution?
So I wrote a piece which Bill did us the courtesy of usefully on. It's called "Achieving Change at the FTC," And there are models on how you do law reform. The most famous one is probably Thurgood Marshall and the NAACP, and that was a decades-long effort, but with the NAACP. But if you, all of us on the panel, the FTC alums participated in a much smaller but successful effort in hospital mergers, and that required. Using the Bureau of Economics, it required a multifaceted approach to try to figure out. The government had lost 7 cases in a row and had literally given up. I mean, the Justice Department ceded. They said, you can do all the hospital mergers you want. Nobody wanted to do them anymore. And we sat down and said, well, we'll the courts were wrong. And one of the reasons they were wrong was they were relying on Alzinga Hogarty, and Ken Alzinga said he was willing to testify and say 2 things besides all the normal economics. He was willing to say, 1, I can't imagine why anybody would use this article for hospital mergers, and 2, I can't imagine why anybody would pay me to say anything so obvious. And that actually influenced one of the opinions. But the point is, there are lots of things that you can do. And the fact that the FTC didn't do any of them, like using the Bureau of Economics, so they didn't like the Bureau of Economics. They didn't like economics. The economists could have, if had I been in her shoes, I would have commissioned a dozen studies on whatever crazy ideas I thought, were big problems big tech was causing. That was in the history of the FTC, was to study those. The FTC, Bill's point about studies is an important one. The FTC picked up the old Corporations Commission, which started in 1903, and it's still a big part of the FTC. There are ways to do law reform, in other words, that are much more than individual cases, and the template is there to do it. The world moved away from those crazy merger cases of the 60s as well, through a lot of things. A lot of steps in law, economics, business that help make those changes. But it's a process that requires an interest more than the Matt Gaetz philosophy of government.
Tim, thank you very much. I think that's a great way to round out the panel. I want to apologize for keeping everybody over a little bit, and thank our really esteemed panelists for joining us, everybody who's tuning in. I think in conclusion, we can say there's an awful lot to keep looking for over the next administration when it comes to antitrust. So thanks to everybody again for joining us, and have a great afternoon.